Ms. Law. State your name.
Sandra Law.
Sorry, here's the scanner for you.
Stephanie Kane on behalf of Ms. Law.
Really? Why are you late?
I know reason. I'm sorry, Your Honor.
All right.
Sorry. We're going to ask for an adjournment on this matter, Your Honor, while we negotiate in this case. I would like to address bond.
Again?
Yes, Your
Is there
Honor.
gonna be anything different than I heard the last two times
She just,
that I denied her bond?
well, Your Honor, she's been in for almost 70 days now, not quite. I think it was like 67 days when I checked. And they're not releasing her to treatment. There's nothing keeping her but your case. My client absolutely does. I'm sorry, I'm a little bit out of breath.
Said
now.
that, the only, like I'm to blame.
No, yeah, I mean, no.
Are you, no, okay, all right, okay.
Judge Washington gave,
No, Cannon, you're doing really well, go right ahead.
no, because Judge
Blame
Washington
me.
gave her a PR bond. So the only case that doesn't have a PR bond with release to the house is yours, is what I meant by that, Your Honor. Yours turning red? Because I feel like I'm turning red. And so, Your Honor, again, my client, she does want to go to treatment. We're requesting that she goes to treatment. If you tether her to her home, she will go to outpatient treatment. We've done the
What
process
would
here.
change my decision from the last two times that you've argued this? Just give me those.
Well, Your Honor, I believe that the court wants her to be in treatment as well because this case is a drug-based case. She had been sober for a full year. She had been doing her drops, her testing in Judge Washington's, which is why Judge Washington let her go. She came back, she had COVID, she got really, really sick. And then her grandmother passed away, and she acknowledges that in that moment she made a bad decision, one that she regrets deeply, one that she regrets very, very much so. And she just was
I've
asking
seen
for
the
the
movie
opportunity to come out.
Groundhog Day.
I have, Your Honor.
Yeah.
I really have. It's a
And
great
it's like
movie.
it just repeats and repeats and like,
My client asked me to ask you to
know.
please reconsider, Your
and
Honor.
I want her in treatment. I really don't want to hold her.
I understand.
But, and that's why I said, treatment, great. But do I trust and will I release her on a straight PR? At this point, I will not.
And Your Honor, thank you. My
Can I
client,
speak, Your Honor, for a minute, please? I wrote you a letter and I signed up for schooling to start January 5th for psychology. And I do have a job and they only hold it for me till February. And I do have a house, which you know the situation, and we have a court date tomorrow with you, with the Sturman Serenity and the Thomas Berry case. And I please ask you, because Judge Washington did want me to go to treatment, and I've been in her court with her since 2023. And I promise you, I will get into intensive outpatient treatment. I promise you, you will have no dirty drops. I will drop 2-3 times a week for you. I don't want to lose my schooling, my house, my job. I've worked so hard for 2 years to get sober and work with Judge Washington. I promise you, she's put me on house arrest tether, not a GPS. So I could only go to work for my 3 months of probation. I promise you, I will do your court with flying colors if you please PR upon me to go home so I don't lose everything I worked so hard for. I wrote you a letter, Your Honor, pleading and begging you to please. I don't want to lose everything. I don't want to have a gap and go backwards in life. I've been an addict for 15 years and it took me 2 years to get where I am today for one relapse over a death in the family that I've beat myself up over. I've went to my doctor. I've cried to him. He had put me on a cocaine blocker called Topamax. So if I ever came across a situation like this again, where I've had a damper in life, I would have the blocker to stop me from using. It was a one-time relapse. And like Miss Washington said, the old Sandra would have tried to beat the test, beat the system, just not dropped and missed the test. And she was proud of me that I didn't try to beat the system and took responsibility of my dirty drop. And I did. I didn't try to do anything to beat it. I didn't try to, I just, please, I beg you, I will You'll not have to ever put me in jail for a dirty drop again. I promise you that on everything I love. I don't want to lose what I've worked so hard for. It's been a struggle for me since 2023, working with her to get this far. And, I was already on the tether, set to go to treatment the day I had court with her. And that's what stopped me from going, because she was gonna put me into a long-term treatment, but then when she realized and evaluated the case, she said, no, I'm not gonna do that to you, Ms. Law, because she knows the struggle I had and how long it took me and how hard I worked to get where I was. And I can't say anything but to please give me that chance. I've never been in front of you, and I promise you, you'll never have to ever worry about me being in front of you for a dirty drop again. That's all I can say, Your Honor, please.
I'll adjourn this matter to January 22nd, 2026, 9 a.m.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Glenn appearing on behalf of Mr. Myers. Can you please state your name for the record?
Brandon Myers.
Thank you, sir. All right, what are we doing?
We would like to request an adjournment, and when appropriate, I'd like to address bond.
Do I have a green sheet?
Oh, yes. I will.
Probable cause conference in these matters will be adjourned to January 22nd, 2025, 9 a.m. All right. Yes.
Okay. Your Honor, we are requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house.
No,
I'm sorry, to his mother's
my
house.
mother's in the courtroom too.
She has a lot of health needs, and she has,
Is this the same motion that I already denied?
You've never done the motion.
Oh, yes, you did. The motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that enough? She's in the courtroom.
he wants to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
I went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008 and you said you did know my mother. She's right there, the light skinned lady.
The light-skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay,
Her right there.
hello. Okay,
Okay. Your Honor, we believe tethering him to the house would keep him from interacting with the complaining witness. And he is well aware of the PPO and this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
what?
No, I don't give you no hard time either. I do what you do.
People can give me a hard time. You go back, you can ask that young lady. Is there a response from the people?
Your Honor, since this motion was already brought about a month ago, we asked the court to be denying it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees. They're also showing up at the victim's church, creating a where he also.
That's a lie.
Safety of the public is necessary, and that bond should be continued.
I ain't threatening nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, then maybe the parties can stipulate to something, but I'm not at this point going to change the bond or the court's decision. The motion for bond reduction is denied.
Thank you, Your Honor. Of Mr. Davenport, can you please state your name for the record, please?
Davenport.
Thank you.
Your Honor, we would like to set this for a preliminary exam.
All right. Discovery is complete.
Yes.
Oh,
Your Honor, I don't believe discovery is complete. I discussed earlier, originally we are gonna set for example, and I thought we discussed the second time we were gonna adjourn for that discovery. Is that that?
Your Honor, Stephanie Cannon on behalf of Mr.
So
Davenport.
you didn't give the information to Ms. Glenn?
I
Is
did,
that no?
I did
That's
not,
a
Your
yes or
Honor.
no response. Don't
I-
worry about it,
I-
you're not in trouble.
that is correct. Your
What?
Honor.
That's a yes or no, right?
Yes, it is.
You did not give the information to Ms. Glenn, and so she took the instructions that she had them,
Yes,
correct?
that is correct.
Okay, now that we know that you have fallen down on the job and that there is needing to be an adjournment, you can sit down.
Yes, no.
No,
still
I
can't
don't need
sit
to hear
down.
from you. Sit down.
Still can't.
Sit down. I don't need to hear from you. I'm only gonna hear from Ms. Glenn. Don't try to whisper in her ear what to do. I'm gonna adjourn your case out till they get all the discovery.
Okay, Your Honor, we would like to request an adjournment. We also would like to make a request to allow him to return home.
Probable cause conference will be adjourned. Well, where's home?
Where's home, Mr. Davenport?
Ann Arbor,
Ann Arbor?
3310 Fernwood Ave.
Oh, he wants to return to his home address.
Yes.
It's not like, you made it sound like he lived in another state. I'm like, what state is he? Where's he? Okay.
And Your Honor, people were able to confirm with the victim that they are no longer living there, so I would have no objection to allowing him to return home and lifting the no-go too.
Motion for modification of bond in terms of the no-go to. Granted. Because of Ms. Glenn's wonderful argument that was made.
Thank you.
So you may return, the no-go to will be lifted on that. And I will adjourn, given that, I'll adjourn this matter out January 29th, 2026, 9 a.m. or as your invite indicates, bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you for your patience with Ms. Cannon.
State your name for the record, please.
Alicia Wittenberg.
And Your Honor, 28 days ago, I submitted a 14B recovery court referral.
Yeah.
I have only today, after emailing them 7 or 8 times, have I heard back from them. So unfortunately, she hasn't even been processed yet. When I spoke with Mr. Reyes from that court, he advised that he didn't even know that she was in custody. So that as well as the fact that you submitted, you signed an order for her release to treatment. I've tried to be in contact with Sarah Stewart, who is handling her case. I submitted that on day 1 as well when she went into custody. Sarah Stewart still hasn't gotten back to me. It's been 7 or 8 times that I've contacted her. Ms. Wittenberg has been in for the last 28 days. As I stated, she was in on a bond violation. Your Honor, at this point, I do need to adjourn her case for the processing of the 14B recovery court referral. However, I am going to again renew my request for her release. She is working in intensive outpatient therapy with U of M. She has submitted that to the court prior as evidence. I want her to be able to be processed in one way, shape, or form as soon as possible through no fault of her own, as she's just sat in jail.
Well, yeah, I know. And my concern is I realize there are delays trying to get people into treatment. There are 2 avenues here where something should have happened and not
Correct.
has.
Yes.
That concerns me.
Not yet, if any.
And I would prefer, quite frankly, if there's going to be a process where she can get into a recovery court, that's going to be the best shot for her. Right?
Certainly.
So,
Mr. Reyes did advise, because he didn't know that she was out of custody, that he could, if she were to get out of custody, he could give her a call and set up an
okay, but
appointment
what
by
if she's
Friday.
in custody?
If she's in custody, he said he would need to set up an appointment with her that they still haven't unfortunately done.
Turn her out to the 22nd, 2026 at 9. At this point, I'm going to continue her bond. I will consider something different if she's not, if we're in the same boat on the 22nd. I will certainly look at some way to do this differently so that she can get assessed. She's just waiting. I don't think she should have to. I get if there's not placement. I get if decisions aren't made, but at least it's a preliminary part of assessing. We need to be able to get that done.
Yeah, I know that she stands to lose a lot, including her job, Your Honor, and I know that she wanted to speak to that aspect of it. I don't know. I know you've already made your ruling, Your Honor, but
What do you want to tell me, Liam?
The only thing I was gonna say is I do have good private insurance and that's, I have called myself and was told that I could get in under my own private insurance, but unfortunately, because I'm in here, I can't. If I was out, I'm just feeling like it could be faster than
Here's
waiting.
what I'll do. I'm gonna set it for the 15th. Somebody needs to do that. Mr. Manager, if what she's indicating, get me some information that says that she can't do it while she's in custody, and then I'll reconsider everything, but I'll just put it out 1 week for him to get that. We'll take a look at it. Fair enough?
Yes, thank you.
You're welcome. Thank you. Court calls case People versus David DeLucia.
Mr. Ginyard, can you please take a name for the record?
Terrence Michael DL and Ginyard.
And Your Honor, we're here for PCC today as well as the community corrections warrant. And I just want to first start off with the PCC. I am still working as fast as possible. I've talked to Mr. Cook about this case. He was just assigned to it after Mr. Overwater. So I am working to get a resolution as quick as possible on this. So I would be asking for adjournment for 2 weeks.
I'll adjourn the probable cause conference to 22nd,
As
2025, 9 a.m.
26, Your
The
Honor.
bond violation.
As to the bond violation, Your Honor, I did send into the court some a urinalysis as well as a lab that was taken for blood that goes back 2 weeks in response to the allegations that he was testing positive.
Where do you have that? Where do I get the indication that this test goes back 2 weeks?
May I approach, Your Honor?
Yeah.
Okay, all right.
What I'm going to do, record to reflect to have bench conference in this case. Right now, he has a no bond bench warrant because of 2 tests. I've received other information that quite frankly isn't inconsistent with the testing because it could be low. His testing could indicate low or no use within the past 2 weeks. I will adjourn this matter out, set it to the 22nd. I'll adjourn it out 1 week to the 15th, 2026 at 9 a.m. At this point, however, the defendant's bond is revoked. I will indicate that based upon the request from counsel. Once I can get a straight story on this, then I will consider at that time his release on a scram tether as opposed to the sober. But at this time, defendant.
Right.
Letting you know that.
Your Honor, can I speak 1 second? I'll make it quick. So on here, I don't think what you did see, I know it says that the CDT result 1.4 is consistent with low or no alcohol. But at the top, it says my current result and flag is 1.0, which means it's under the 1.4, which could be low or none. So my test is 1.0. Okay,
He did read it.
all right. That's all, sir. That's all I want.
And I also know, so that the record
Yes.
is clear, that on the Soberlink, on 2 occasions, you tested positive. And on the retest, continued to test positive.
Understood. That's why I pay for this test though. sir. So,
I understand why you did it,
yes,
but I'm saying, I'm telling you how this looks,
understood.
all right?
Understood. Yep.
And the only reason I may consider release is because of the advocacy of your counsel. Because normally I wouldn't consider release. Normally what I would do is I just revoke your bond and you're gonna sit there.
Yes, sir.
But I'll bring you back in a week and we'll look at it again.
Yes, sir.
Thank you.
All right, thank you.
Thank you, Your Honor.
I got it.
Let them go back, okay?
You say
I put it out, instead of 2 weeks, I